Hi, I'm Simone Elbow, your HR strategist and host of Ask HR, where you get answers to your burning HR questions. Today, I am so excited about this show because we are going to be talking about all things employment law. That's right, you're going to Employment Law 101. And today, I am pleased to welcome as our special guest Tyrone Fitzgerald, who is an attorney, he is a consultant, and he's also a professor of all things law, business law, and human resources practices and policies and employment law, among so many other things. And so I'm really excited to have him as a part of the show. Welcome, Tyrone.
Thank you, Simone. Thanks for having me.
Yes, I can't wait to get into this discussion because I think that this is something that people do have burning questions about, not really understanding the law and how it's interpreted and how practices evolve from the law and how to really structure their businesses. So I think that this is an important conversation to have right now.
Yes, it is. Very important, just so that employers understand what their duties and responsibilities, their obligations are as we go through this pandemic. In addition to employees, so that they understand their rights and their duties and responsibilities to the employer. It's not a paid vacation, unless you've agreed to that. It is a situation where everyone has to face a new normal, whether that's working remotely or being laid off temporarily or being made redundant or what have you. So it's very critical that people understand both the rights and responsibilities and duties, employer and employee.
Absolutely. And so I definitely want to touch both of those aspects as we talk today. So let's talk about the employer responsibilities first, and maybe just touch on an overview of the employment law itself. Like, what are the key aspects of the law that business owners should be aware of?
Well, certainly you have to reference the Employment Act, and by extension the Employment Amendment Act 2017, which speaks specifically to layoffs, redundancies, and what have you, and what the terms and conditions, in addition to whatever may be those terms and conditions in the employment agreement or contract, in terms of consultation, in terms of how it's done, in terms of timelines, when a layoff then translates or becomes a redundancy. After a certain number of weeks.
And so redundancy, let's talk about that quickly, because I know initially in, I think, the original Act of 2001, redundancy spoke to if there was no longer a need for a particular role or department, or the business need for a particular aspect of the business was no more.
Right.
Is that still the case with a redundancy?
Yes, it is still the case with the redundancy, although there are very specific terms and conditions upon which redundancy may happen. And in terms of how redundancy pay may be calculated, what is the maximum cap in terms of what the entitlement may be. But definitely, I think everything needs to be put in the context of the basis of employment law, which is the employer-employee contract. A lot of what we tend to reference would be the statutory rights, obligations, terms and conditions. But there is a contract, first and foremost, that the employer has with the employee that forms the basis or foundation upon the relationship that we have with each other, whether we're an employer or an employee. And that's the first point of reference.
So let's stick a pin right there. Do you think that a lot of people will create contracts for even an entry-level employee, and should they? Because oftentimes people may just get a letter, or they may get a phone call and say, hey, you're hired. And then they start getting pay slips. If they get pay slips, they just get a paycheck or they get a deposit to their account. What are the obligations of an employer when they hire someone?
Well, the interesting thing, Simone, is that an employment contract can be oral,
Oh,
or it can be written, or it can be a combination of both. It doesn't necessarily have to be written. Now, the best practice and the traditional sense is to have it in writing.
so how do you prove an oral contract?
Well, the most obvious way to prove an oral contract is you would have to have some affidavit evidence, or what I always tell persons is if a lot of it happens over the phone or whatever, you follow it up with an email. It is my understanding, or these are the terms
So
and
still
conditions.
some form of writing.
Right, just to support that. But ordinarily, you would have to get some sort of support, some sort of affidavit support to kind of confirm that it was an oral contract. But
Okay.
oral contracts, written contracts, or a combination of the two are legal.
Right.
And for the most part, even where there is not a proper understanding that there is an agreement, there may be one by virtue of the conduct of the parties. So if I tell you, I offer you the job, you accept, you have all of the valid elements of the elements of a valid contract, and you appear on Monday on the job, then, and then I continue letting you work at your post and I pay you on
pay me,
Friday,
yeah.
that's a contract. You understand?
Yes.
So it's very interesting, and people need to understand, how it works in terms of, do I have a contract, when a contract is made, and that employer-employee contract is the foundation of the relationship. That forms the basis of the relationship. The legislation provides the statutory framework that supplements, and in some instances provides for terms and conditions where
There is a guideline, right?
Right,
Where you work, who you report
exactly,
to,
right.
that type of thing,
Right,
hours of
right.
work.
Or if the written or oral contract does not speak to a particular element, then you can look by reference to the legislation to see what it says for that particular aspect.
That feels risky to me, though. I mean, it seems
what
so
way?
open-ended to me. Like, I don't know. I mean, maybe should there be perhaps the employee handbook then that may speak to further details of
Yes,
what's
and-
required and policy? I guess for me, I'm thinking risk later on if something were to happen, if there were maybe conduct issues or something like that, or just misinterpretation, miscommunication, misunderstandings.
Right.
Those things happen.
Right.
And then, as we would say, here in the Bahamas, when row day comes, right, it becomes maybe your word against mine. Well, you told me I could do this, or I had this. Now you're saying no, or you changed it in the middle of the game. I've been working for 6 months and now all of a sudden, no, I can't do, or yes, I have this benefit, or no, I don't have it anymore.
But Simone, you'd be surprised because one of the fundamental common law principles with regard to the employer-employee contract is the fact that you cannot unilaterally vary a contract unless in certain specific circumstances, because there has been some recent case law that has spoken to that. But ordinarily, it has to, any variation of that contract has to be with the mutual agreement and consent of the employer and the employee.
And those variations would include what? Like in this time now, change of work hours, clearly.
Whether I'm going to, in fact, have a paid leave or not.
Right.
Whether I'm going to have an unpaid leave, that is not a unilateral decision of the employer. That you must obtain by whatever means that is the proper protocol. You must obtain the consent of the employee for that to happen. So I just can't tell you, okay, you're taking your 2 weeks paid leave, or you're taking unpaid leave or whatever. You have to get my consent.
Wow. Isn't that what's happening?
Yeah.
In some cases?
Really?
I
No. The reason why I say really is what's the language coming from a lot of, particularly the big companies
Right.
with the benefit of legal counsel.
Ah.
Okay. The fact that I'm referring to an ex gratia payment. Okay. There's a reason for that.
And what does
The
that mean?
Well, you have to look at you have to look at it in the sense that it may be ex gratia in the sense that it won't be an unemployment benefit coming from the company or whatever if you're temporarily laid off. Because however it's classified or rolled out or interpreted to be, then that could imply other legal obligations. So I have to be very careful. You understand? But the point is that because it is a contract that is entered into by both parties, sometimes we believe that the employer has the stronger position because they are the individuals or companies who pay the salaries and what have you. But like I said, certain terms and conditions, well, if there's going to be any variation, in most cases, it has to be with the mutual agreement and consent of both parties.
And
for it to
can
happen.
that consent be oral, or does that have to be in writing?
That could be that could be oral or in writing.
Interesting. I guess this oral thing is really throwing me because I'm just trying to figure like if this were to go to court or something, like how do you?
It's not recommended in terms
Right.
of a best practice.
Ah, okay.
But it is a legal means
Okay.
nonetheless.
Okay.
You know, we're so conditioned to accept that everything must be in writing.
Yeah.
Okay, and that is true in terms of best practices. However, like I said, there are avenues in the law, not avenues in the law, but there are certain principles in law that allow for
that
right. An
contingency
oral, right,
if
yes,
that were to be
yes,
the case.
Right.
So let's talk about then policy as it relates to the law, company policy.
Okay.
Is what I'm talking about now, and the role of the employee handbook. Should every company have an employee handbook?
It is advisable and highly recommended that you do have an employee handbook because that protects the employer and the employee. In that, a well-drafted employee handbook would speak to a lot of the aspects that you have concerns about in terms of code of conduct, code of ethics. What happens in certain situations. It could also make references to the business continuity plan. What is the policy when we experience a pandemic?
Right, or a hurricane or some other disaster.
And it's very important that employees have a reference to go to in case there is any doubt. And then they can follow up by asking questions of the HR professional or the supervisor or their manager. Let me go back and speak to something when we talked about the employer-employee contract. Oftentimes that is not a 100, 200-page document that speaks to everything.
Right.
Let me be clear.
Right.
It speaks to what the standard terms ought to be and what the Employment Act requires to be in there. For example, hours of work, salary, those types of things.
Vacation. The title of the job.
Okay, right.
Maybe a basic description of responsibilities.
Exactly.
Who they report to.
Well,
not necessarily.
Not from a legislative perspective.
Okay.
But there are some things legislatively that must be in a standard contract of employment and in the
termination conditions
exactly.
of the contract.
Right. Now the other things that you speak to in terms of how the operation is to work from a human resource perspective, that would be references to the employee handbook.
Okay.
And you could make that very clear in the interview You can even make some reference in the actual contract that this would be supplemented by the employee handbook, the code of conduct, the code of ethics, which you sign off on, those types of things.
Right.
And so I want to point that out that
Right.
the employee contract is not going to speak to everything in
Everything.
your contract. In fact, some people have a 1-page, 2-page contract. Other people have a 30-page contract if you're more at the more executive level. But it would certainly not speak to everything. You would
Right.
have to make references to
And
the
supplement.
right, and supplement it with the employment handbook.
So let's talk a little bit before we close this segment about some other aspects of the employment law that sometimes may get misinterpreted or not executed according to law. Things like overtime, things like vacation leave, and other matters that relate to the law, and other things like maternity, other types of leave that the law speaks to. So let's talk about overtime first. How should overtime be calculated? Because of course, we've had some practices, right, where people will say, well, they're not getting a full work week anyway, right? So if they have it's a 40-hour work week,
Right.
and maybe they've given them some days off. They
Okay.
haven't worked a full 40-hour week. So if I ask them to work 12 hours on Monday, I shouldn't have to pay them overtime because in the scheme of things, they're still only working like 30 hours a week. I know some employers that actually think that way. Now, I know that I was told
Okay.
that overtime is calculated on a daily basis. Whatever you work in excess of your 8-hour day is overtime.
Well, it really depends on how it's calculated. I think the legislation doesn't go into the nuances or the mechanics of how it is to be calculated. I think people may make the recommendation that it's after so many hours per day, and then overtime kicks in because that may be a best practice from, let's say, an accounting perspective or an HR perspective in terms of compensation and benefits and all that other stuff and how they calculate. But the law simply gives you the stipulation of the 40 hours. Anything beyond that is considered overtime, and it spells out how that is to be calculated. Now, how you determine that within those specific guidelines is entirely up to the company once it complies with those parameters.
Okay.
Okay. And what I need to say is this. I think sometimes employers are not as aware as they ought to be of what the law specifically states or references or what have you. Certainly our employment legislation is a sound one, but there's a lot to be improved upon,
Right.
and that happens as business practices and employment practices evolve. We're still fairly new at this. Unlike the United Kingdom or Canada or the United States that are well advanced and very progressive in some respects with their legislation, we're just catching up and keeping pace.
Right.
And likewise with employees, it's very important that they understand their entitlements,
Right.
what their rights are,
Right.
what their benefits ought to be.
Right.
And sometimes we kind of get down to the nitty gritty for some things that could easily be worked out by mutual consent and agreement based
Right.
upon that employment contract.
Right. Because I know that the Department of Labor always says our law is a minimum standards law.
Yes.
So you can do better than what the law
yes,
provides
definitely.
once you maintain
Excellent
it.
point.
You're
Yes.
able to maintain that.
Yes, and we must remember that it is a minimum standards law, and so you can build upon
Right.
and exceed those minimum requirements or standards
Right.
within that work environment.
So what about the lunch hour? I know that has been a huge debate. Where does the lunch hour fit in this 40-hour week?
now, when you say where does it fit
As
in?
far as if it's paid or unpaid, because you have some employers where your hours of work is really a 9-hour day, not an 8-hour day, and the lunch hour is unpaid by the company, it's on your own. So your hours may be 10 to 7 or 9 to 6, and that 1 hour for lunch is yours. But I still get 8 hours of work a day.
Okay.
So I've seen some interpretations like that.
Like that.
Right. That the lunch period may or may not be paid by the company.
Well, again, I think that is the subject of interpretation in terms of how it's rolled out practically. Now, keep in mind now, one of the duties and responsibilities of an employer is to ensure, and we're going to get to this, with this whole pandemic, the health, safety, and well-being of the employee, which means that they should have the relevant breaks, whether that's 15 minutes, 5 minutes, whatever, but that's paid. You can't say, okay, could you imagine how cumbersome that would be?
How to police that?
Okay.
Oh, I'm going on my 15-minute break now.
So
Can you clock out?
Okay, let's clock out. Let's deduct this, whatever. So I use that same example with lunch. My interpretation is lunch is included in that period in which you are compensated.
Right, but it's not for all companies. I can tell you that.
But
practices
a lot of companies,
I've seen.
Right, but a lot of companies take a very literal approach to that.
Right.
And they probably offset that with something else.
And it does become a challenge because when, say for instance, a workday gets very busy and you have employees that don't take lunch. Or they end up maybe eating at their desk or doing something, right?
Do I get that back as overtime?
And that is the question.
In terms of, can I exchange that for time off?
That's what the question becomes.
Okay, so that's why I flip it. So you see how technical and how exact we say it can become, and it need not be.
Right.
You understand?
Right.
Because it's a slippery slope. When you start down that train of thought.
Nitpicking and nickel and diming.
Exactly.
Yeah, absolutely. Right. This is awesome, and I can't wait to get deeper into this. I want to talk about the employee rights and responsibilities when we come back after our break.
Sure.